We're live.
Good morning. This is Senate Judiciary, January 24th, 2023. I'm sorry that I'm not in Montpelier to join you. I'll be leaving shortly after this meeting to get to Montpelier. I had difficulty getting in aid from my wife this morning. 7 a.m. I had the car warmed up and was ready to head north. It's back in the garage. So we'll get started. I thank you all for your understanding and your patience. The first witness is Julio Thompson from the Office of Attorney General. This is S4, an act relating to custodial interrogation of juveniles.
S6.
F6, I'm sorry.
Good morning. For the record, my name is Julio Thompson. I'm an Assistant Attorney General and Director of the Attorney General's Civil Rights Unit. I'm picking up a little bit on testimony I provided last week at the end of two different committee hearings regarding S6, which regards the use of deception in juvenile interrogations. As I mentioned last time in the closing minutes of my testimony, our office supports legislation that would prohibit the use of deception for young Vermonters, and we can have conversations about how young is young. It is something that we support for really three main reasons. First of all, as you've heard previously, there's a substantial body of empirical evidence that show that juveniles are susceptible to making false statements in a custodial setting when questioned by an authority figure. Sometimes they do that because they perceive that there's no choice but for them to make those statements in order to realize the short-term gain, like going home, if they're under the belief that they would be released. And sometimes it's just simply that they question their own memory as compared to statements that are made by adult authority figures. The second reason is that the existing constitutional standard, which focuses on whether the state has been compelled, not whether the statement is reliable or truthful, really doesn't keep up with the science. The Supreme Court case that first recognized that deception was a permissible police questioning practice was a case called Frazier versus Cupp. It was decided in 1966. It involved an adult accused of a crime and was falsely told that his alleged accomplice had already implicated him and therefore was in his interest to confess. The Supreme Court said that use of deception did not render the suspect's statement involuntary. It's important to reflect that the Frazier versus Cupp standard, which is still the basis for the protections under the common law today, was decided at a time when none of the research on brain science involving adolescents or young adults existed. It was in 1966, where it would be another 7 years before the field of psychiatry and psychology recognized that homosexuality wasn't a mental illness. That places that case law in context, and so there's been substantial evidence not only from exoneration such as the Innocence Project, but experimental evidence where psychologists, sociologists, criminology conduct experiments to see whether to what extent individuals will provide false statements when placed in circumstances where they're being told facts that are not facts. The third reason to limit the discredited practice of using deception for juveniles is it's an important step towards increasing law enforcement legitimacy and procedural justice. It's well settled in other professions that you cannot use deception to gain an advantage in carrying out your duties. For example, as I mentioned briefly before, the rules of professional conduct, which govern prosecutors, would prohibit a prosecutor from making false statements to anyone about the evidence or about the law or about whether they should expect leniency. The standard says that it is unprofessional conduct to, quote, knowingly make a false statement of material, fact, or law to a third person. In our rules, our ethical rules, it doesn't matter whether they're in custody or not. It doesn't matter whether they're adults or not. I think it's become a little bit anachronistic these days that in an investigation of a juvenile suspect, the prosecutor entering the room can't make misstatements about DNA evidence or about whether something is a crime or not, but as soon as they leave, the police officer is free to do so without any consequence, taking the chances that maybe in the totality of the circumstances, any statement that the suspect makes might be admitted. And if it's not admitted, because it's deemed involuntary, there typically is no consequence to the officer for engaging in that conduct. What this law does is more than govern admissibility. It flatly says this is a practice we don't want law enforcement to engage in. The reasons for that, at least in the other states, the other 5 states that have enacted similar prohibitions, is that this is an area that is fraught with risk and that undermines law enforcement legitimacy. It's not unusual for legislatures to raise the floor above a minimal constitutional standard to govern police practices they find problematic. Only 2.5 years ago, we all sat here and considered legislation that ultimately passed that raised the standard for the use of force and flatly prohibited neck restraints unless deadly force was justified, notwithstanding the fact that there's a lot of common law dating back to the late 1980s about what constitutes objectively reasonable force in their cases, interpreting the reasonableness of neck restraints in given cases. Legislature looking at not waiting for a case for a Vermonter to have died from a neck restraint, but acting proactively. Thought that kind of technique was so fraught with risk and was so associated with distrust of law enforcement that they just went ahead and acted. And I think a similar prohibition in this case, I think will be another step in modernizing and continuing to raise professional standards.
I'm going back just a moment, but can you remind me what the 5 other states are that have legislation like this and if they are limited to juveniles?
Sure. So the states are Oregon, Illinois, California, Delaware, and I'm missing one here. So I'll have to.
The Connecticut?
Connecticut hasn't passed the law yet, so I'll have to look at it. I think I have the last one. And the maximum age for all of them, the oldest is 18,
Okay.
and the youngest age is California's, which is 17. Utah is the 5th state.
Another question. Thanks, Julio. I'm wondering, I read your testimony as supportive of the bill in terms of particularly deception, but we had testimony where some witnesses were drawing a distinction between deception and psychologically manipulative interrogation tactics, and they seemed more in unison on the first than the second. Can you just zero in on the psychological manipulation and give us your thoughts on that?
Sure, it's definitely, as it's written here, and this language that's in S6 doesn't correspond one-to-one to any other state's legislation regarding prohibited practices. The term itself, the manipulative practices, does reflect language that's in the California statute, but the California statute offers a different definition. I think that, I guess what I could say is that it's easier to have a rule that has a consequence as S6 does, which is to have a presumptive inadmissibility rule than it is to have presumptive inadmissibility for other aspects of police interrogation. For example, depriving someone of reasonable water and meal breaks. It's difficult for an officer to know the level of need for a person, It's not that difficult for an officer to know when they're lying about facts, whether they're lying about whether leniency is a promise. And so it is easier to hold an officer or to hold the law enforcement, the government accountable for practices that clearly unnoticed are not permitted. It becomes a little more difficult to have that same sort of automatic consequence when you're talking about how long is a reasonable time to give someone a break before they, before they continue speaking. And so I could understand why it would be easier to focus on deception. I'm not saying that there's no room for other practices as well, but I think it's, well, to compare it to California, California does prohibit these psychological tactics. They have a somewhat broader definition to some extent, but they also don't have a presumption of inadmissibility of the statute. It just says that these practices are prohibited. So I think that there's room, and I think I would want to hear more testimony if the committee wanted to go beyond deception. But I think that deception is, I think is an important first step. The most widely taught method of interrogation in the country, probably the better part of the generation of law enforcement, is this method we keep calling the Reed method, which is founded by John Reeves, a former polygraph examiner from the Chicago Police Department in the 60s. The Reed core teaching is that one of the most effective techniques when you're seeking to induce a confession is deception. That's one of their most powerful techniques, and that's one of the reasons why the Reed method has come under a lot of criticism. It's also a reason why the Vermont Police Academy doesn't teach the Reed method, and the state police don't use the Reed method typically. But even the Reed method, so that's not a technique you would be using on adolescents. And then there's some discussion in the training materials about emotional maturity for older adolescents, etc. But it is a core practice, and it's a big area. And I think another reason why I would say it's an easy advancement in the law here is that Vermont, at least on paper, doesn't embrace it. The police academy, like I said, doesn't teach it. Our largest police department doesn't use it. And yet there's no, as far as I know, we have 83 police departments in the state. I'm not aware of a single department that says you can't use deception in a juvenile interview.
That says you cannot?
That says you cannot. I'm not sure I've seen a policy in the state that governs what the rules of play are in juvenile interviews. As I mentioned earlier, I myself worked on interview and interrogation policies for the Baltimore Police Department in connection with the city there and the Department of Justice and a court-appointed monitor. And I think I briefly mentioned that the New Orleans Police Department since 2018 has had a very detailed policy governing interrogations, which includes a flat-out prohibition on deception when interrogating juveniles. But Vermont hasn't to date really sought to govern itself in this area. So if it's a practice that's been abandoned, I don't know if it places much of a burden on law enforcement, but at least it places some clarity that this is a practice that we don't embrace. And I mentioned earlier that the largest police organization in the world, the International Association of Chiefs of Police, recommended 9 years ago, or stated in 2014, in a publication I provided to the community online, that this is a practice that is highly susceptible to eliciting false statements from juveniles. So it's something that, and I've mentioned, the Innocence Project has mentioned that the world's largest police training organization, Wicklander Zulowski, or WZ, has abandoned that approach since 2017. They did it first with the Chicago Police Department when they were engaged to train that department after the Department of Justice had found a pattern of practice of constitutional violations. So this is somewhere where the profession is moving in any event, and it seems to me to be a reasonable step forward. You may wish to take other testimony from folks who are knowledgeable in me about what is the upper limit, but we think that 18 is at least the minimum. We wouldn't recommend going down to 17.
So if we were to adjust this for raise the age and include 19-year-olds, that would not be an issue.
I think for 19-year-olds, I don't think that would be problematic for our office. I also just want to address, if I have a moment or two, address a couple of the concerns that we heard from some of the witnesses, and I think it's great to hear from a lot of voices, but there are a couple of concerns I think were a bit overstated, in my opinion, or at least weren't as persuasive as it might be to others. One was that it was confusing to adopt a statutory standard when we have constitutional law and case law on that. I mentioned previously the legislation enacted just a couple of years ago about neck restraints. Well, Graham versus Connor, which is kind of the seminal case about use of force in policing, was decided in 1989, and the legislature didn't find that to be an impediment. And I'm not aware of any confusion in law enforcement of Vermont about whether or when one can use a neck restraint. Similarly, legislatures everywhere routinely enact laws that are otherwise covered by constitutional minimums because there is a desire to go above the constitutional minimum. I work in the civil rights unit, so one of the lone star pieces of legislation that we come back to again and again is the Civil Rights Act of 1964. When that was enacted, there was already an equal protection clause in the U.S. Constitution. And there had been case law that had been building over decades about what constitutes equal protection for people in our country. And nonetheless, legislature set forth standards, even going beyond that. The Equal Pay Act of 1963, signed by President Kennedy, was already equal pay for at least government employees was already governed by the Equal Protection Clause of the 14th Amendment. It's pretty routine that legislature can build upon constitutional standards, and that courts can interpret the statute as separate from the separate for the Constitution. Another thing I heard, and I just think that this is, I'm not sure how strongly this was pointed out, was some confusion about whether the presumption would be confusing to use the clear and convincing evidence standard to allow something to be admitted notwithstanding violation of the statute. I have to say, as a longtime practitioner, more than 30 years now, the clear and convincing standard is very well settled in the case law, and indeed it's written throughout our statutes. Perhaps somewhat ironically, the 1993 law the legislature passed that would allow someone who's innocent but was convicted of a crime to seek damages for a wrongful conviction has to be able to prove their injury by clear and convincing evidence. Extreme risk protection order, which is the subject of recent legislation, uses a clear and convincing evidence standard. In my own world, there's just been recently a bill addressing family leave. It calls to mind to us in the Civil Rights Unit. We enforce the Parental Family Leave Act that grants people up to 12 weeks of leave if they have a serious health condition or a serious health condition of their family member. The standard that the legislature enacted in 1991 there was a preponderance of the evidence standard to establish that you qualify. But if an employer fired someone while they were on leave, the legislature said you can justify or you can defend that dismissal if you can prove by clear and convincing evidence you were going to fire the person anyway, whether or not they took leave. So there's a case where the court has two standards that are in play: preponderance for qualifying for leave, clear and convincing evidence for having an exception to the standard. There's no reported decision in 30 plus years of that law reflecting any confusion about discerning the difference between preponderance and clear and convincing evidence. And our office has enforced, investigated many hundreds of leave act applications, and we don't find it a difficult standard to interpret at all. And so I don't see that as being particularly fraught. I think the reason Oregon, which was the first state to enact this clear and convincing evidence standard. I think some of the testimony there about why they use that standard was that you began with the state, you began from a place where the legislature says we don't want law enforcement to do this. Don't do this. But if you did it anyway, there are going to be consequences for that. We're not going to let most of that come in unless you can really, really convince a judge that this is reliable, not involuntary testimony. That's not that different from the Family Leave Act saying that you should give employees 12 weeks of job protected leave. But if you fired someone, notwithstanding that general mandate, you can defend yourself if you can show by a higher standard of proof that it was really a justifiable act. That's a familiar concept to us who enforce the Vermont laws, and I don't think those concerns are particularly common. I'm available for other questions.
I have one question. I want to make sure I'm clear that you feel that this law would be helpful even without the psychological manipulation, if we were to avoid that part of the bill, to just to focus on deception.
I think focusing on deception will definitely be an improvement. I can't say that it's the end of the story about dealing with police practices, and I think that's so I wouldn't say it's the end all and be all, but I would certainly say it's an advancement in the right direction, and frankly helping Vermont catch up to where the profession has been, or has been moving for some time. Yes.
And do we know if the Reed? I'm learning more and more about the Reed standard or the Reed method, and that relied pretty much on deception. Is that, then that's not used in Vermont with adults either, or not trained at the police academy?
Sure, I'll be happy to answer that. So the police academy has not taught Reed or the Reed method. And I can briefly describe what that is in a nutshell, although it's pretty detailed. But they haven't taught it for, it's going on, just trying to keep track of the pandemic, for going on almost 5 years now. And the state police has moved to a different, more interview style approach called the PACE method, which was pioneered in the UK more than 25 years ago. But I also noted this spring when I was testifying about a different bill that raised the issue of juvenile interviews and interrogations that Reed and Associates, which is the company that teaches the Reed method, had scheduled a 3-day seminar that was hosted at the South Burlington Police Department. So there's no prohibition on it being taught. There's no standard in Vermont governing whether or when any law enforcement officer, after they leave at the academy, use that method or not. To just briefly talk about the Reed method, which again, a lot of social science, challenging how useful or raising us many concerns about the Reed method. There are really two parts to the Reed method. One is basically an interview where an officer is interviewing a subject in an open-ended way without any sort of pressure. And Reed teaches a lot of different techniques for determining when someone is lying or not. And the one part of the social science challenging the Reed method challenges a lot of those psychological assumptions about whether someone who fidgets, looks up to the left, looks up to the right, is exhibiting signs of deception versus signs of nervousness, for example. And so one criticism is that Reed doesn't really teach deception detecting as well as it claims. The second portion of Reed is that once you are satisfied that you're dealing with someone who isn't telling you the truth, then you use the interrogation methods, and there are any number of them. It's not just deception where you're just lying about the evidence, but it's creating impressions. It's using two tools, and the tools are actually mentioned in the California statute. I think they were taking a broader rank payment read. One's called maximization, which either by false statements or by any number of other verbal and nonverbal means, you are overstating the strength of your evidence against the person. The aim, Reed says, is to convince the person that it's futile to keep lying because the case is so strong against them. So exhibiting greater confidence than the officer really has in the likelihood of convicting the person before a jury. That's maximization. And then the other side tool that's used is minimization, which is to use any number of techniques that would minimize or create a perception by the individual that minimizes the consequences to them if they confess. So implying but not promising leniency is one thing. Suggesting that, this will go well with the judge, this will go well with the jury. That's one form of minimization. Another form of minimization is falsely to express sympathy with the person. If it's a high guilt offense, like a sexual assault or domestic violence, to pretend like you understand, like everyone has a bad day, to set the stage where the person will, if the officer thinks they're guilty, will be more willing to become forthcoming. The California statute specifically includes maximization and minimization as two prohibited techniques. It's also noted, California also uses 17 years, doesn't have a presumptive inadmissibility provision, and it doesn't go in effect until 2024. So we don't know what California's 121,000 law enforcement officers are going to be trained on because we haven't seen it.
I think Senator Baruth has a comment, but I'd like one other comment I'd make, Julio, is that, and this is all anecdotal, like I've had some kids that I've worked with who like to embellish what they did. In other words, they want to be tougher than they really were. And so we'll often give information, but if you read the report and read all the other information, you find out that it really wasn't what they said. I had a kid who told people that he was arrested for armed robbery, and what it really turned out was he used a pencil and put it in a kid's back and wanted the kid's lunch money. That didn't really rise to that level, but he was fond of telling people that he was at my program for armed robbery, and we worked through that. So, that falls into this too, where some kids want to look tougher. Just as a point.
Just a quick question about the maximization. So California prohibited that. Does there have to be a mens rea aspect to that? Because it seems you could have an officer who at first blush says, yeah, this case against you is strong, not meaning in any courtroom sense, but I've just gotten a look at the evidence. So to what extent do they need to prove that the person knew they were maximizing?
Yes, it's pretty clear, at least from my reading. And again, this bill hasn't gone into effect, this law hasn't gone into effect yet, so there aren't going to be any court cases. But the statute says their definition says maximization, quote, includes techniques to scare or intimidate the person by repetitively asserting the person is guilty despite their denials, or exaggerating the magnitude of the charges or the strength of the evidence, including suggesting the existence of evidence that does not exist. So the acts of scaring and intimidating are long understood in courts to be intentional acts, as is exaggeration and suggestion. Minimization is defined. It says it includes minimizing the moral seriousness of the offense, a tactic that falsely communicates that the conduct is justified, excusable, or accidental. So, in a homicide case, saying, we know you didn't mean it. Well, does the author really know what the person is? I think that's what they're getting. And It also included within their definition of psychologically manipulative tactics, it includes language similar to what Vermont has about leniency. It says it's, quote, making direct or indirect promises of leniency, such as indicating the person will be released if the person cooperates. They identify a third tactic, which hasn't come up in the testimony, that I'll just mention here for completeness. It says, quote, employing the false or forced choice strategy, whereby the person is encouraged to select one of two options, both incriminatory, but one is characterized as morally or legally justified or excusable. So it's, confessed to crime A or crime B. There's no option C that's offered. That's the strategy that they're talking about. And again, the language of finding that this is a strategy doesn't necessarily imply that these are intentional acts. I will point out, in terms of defining terms, Vermont has many statutes that prohibit deceptive conduct and offers no examples of what deceptive conduct is. A large section of my office, the Public Protection Division, enforces the Consumer Protection Act, which prohibits unfair and deceptive business practices. It doesn't offer a single definition as to what counts as unfair in the business context or what counts as deceptive. Our statutes governing mortgage lenders, bankers, escrow agents, all prohibit them from engaging in deceptive practices relating to the performance of their duties. We have a criminal statute dealing with home improvement fraud. So that's a criminal consequence that prohibits home improvement companies or vendors from engaging in a variety of or any deceptive practice in connection with the rendering of services. And again, no examples are given.
Senator Norris,
yes.
Hi, thanks for your testimony. Just to clarify, I'm a little backed up on this. Now, as far as the Reed technique is concerned, was it your testimony that the Vermont Criminal Justice Training Council no longer endorses this, offers this, or it's not used whatsoever in the state of Vermont?
The Criminal Justice Council, well, the academy is what teaches, and the academy does not teach the Reed method. It doesn't have an official endorsement about training policies that are offered outside of the academy. It just offers its own training, and it doesn't teach deception and interrogation. And the state police don't do that. So for the Reed and Associates to ask a police department if they'll host the training, and the police departments want to sign up, there's no prohibition on that. It doesn't violate anything in state law or any criminal justice council. They don't address the subject. Anything else, Mr. Chair?
Any other questions?
Thank you.
Thank you very much, Julia. Appreciate it. Appreciate your patience with the committee and having to come back 3 times. Sorry for the timing. Kevin Belonge from the Vermont Police Association is our next witness.
Good morning, everybody. Can you hear me?
Yes, Kevin.
I'm Kevin Belonge. Just want to take a minute and introduce myself. I am the immediate past president of the Vermont Police Association and have been on the board of trustees for over 20 years. I've held the position of president 3 different times. My career background is I'm just a week shy of 2 years retired from the Rutland City Police Department, where I spent a 35-year career there. Spent 29 years working in patrol and 6 years assigned to the community response team based out of Project Vision. So I've been around the block a few times. Our stance on this is that a lot of it is unnecessary. It's a very confusing to read S6 as it's proposed. The psychologically manipulative portion of it is completely confusing. And the majority of what we're seeing in S6 is already covered under constitutional law. And I think we're on a slippery slope trying to legislate constitutional law. We have one big protection already where it comes to a custodial interrogation of juveniles. Before juveniles in Vermont can waive their constitutional rights, they have to consult with either a parent, guardian, or disinterested party. And quite honestly, that party should be with them if they're being interviewed or interrogated. That's always been our stance. This is something that I have never seen a lot of as far as deceptive practices with juveniles. Usually when you're, if you have one in custody, you already have enough. If you've taken them into custody and you're in a custodial situation to charge them, a lot of times what you're looking for is more information on maybe co-conspirators, other people involved. As you know, some of the stuff I see you're trying to address in S4, we do have bad apples both in the adult and the juvenile circuit. It can be anything from a minor infraction up to and including very violent crimes that some juveniles are committing these days. And a lot of times there's someone behind that. And the only use I could see with the deceptive practice, which I've not seen much of, would be trying to get to higher up in the food chain, if that's the way to word it, where say a juvenile is dealing drugs and you want to get higher up on the food chain, you might use a little deception to reach higher and a crime, you know, somebody that may have manipulated them, somebody that's coercing them to do criminal activities. But it would not be very widely used. I can't think of maybe one instance where I ever saw this practice used. Our position is that this would be better off in a policy.
Sorry to interrupt you. We just have a question, Senator Baruth.
Sorry.
Thank you, Mr. Blangy. I was just struck by what you said. You said we might want to use a little deception in order to find out whether somebody is manipulating the juvenile, but aren't we then guilty of manipulation ourselves?
Yes, you could be. And my point being is trying to, you know, go deeper into the investigation, develop more information on a higher crime. And does that make sense?
Well, the intent of the investigation makes sense, but as a defense of deception, it falls apart for me because we're pretty much in end justifies the means territory, especially when we're contrasting with other people who may be using deception on the juvenile. So I think the bill is trying to make a very clear statement that, as Julio Thompson said, as professionals, as law enforcement professionals, we're operating from different standards than others who might be manipulating those juveniles.
And I would agree with that part of it. Yes, I would. It like I said, it would be a very rare occurrence that, and I wouldn't think it would be used to coerce a confession, or at least with the people that I've ever seen dealing with juvenile offenders. You deal with them much differently than you would a 35-year-old offender. Like I said, I've never seen much of this used, but there may be a slight purpose for it. We're not saying that it shouldn't be regulated. I think it would be better off, or we think that would be better off in a policy that the Criminal Justice Council develops. If they developed a policy vastly restricting the use of deceptive practices, they can develop training on it, and it's much easier actually to discipline someone if it's a Criminal Justice Council policy, because they control the person's certification.
If I can ask you a question here.
Certainly.
So if this law were to go into effect, wouldn't it compel the Criminal Justice Training Council to then make policy to adhere to this?
I'm sorry. Can you
No
repeat that
problem.
again? I'm sorry.
Sure. So if this bill were to be enacted, would it then compel the Criminal Justice Training Council to make policy that would adhere to the provisions of this bill?
Possibly. The other side of what we're thinking is that if you define it distinctly in statute, and you have a court opinion or decision that goes against your statute, that will basically nullify your statute. If it's in a policy through the Criminal Justice Training Council or Criminal Justice Council, I'm sorry, that can be a fluid thing where if you have a court decision that changes it slightly, they can change the policy without having to go back for legislative action on it.
Thank you.
So our stance, it really is, I think S6, the way it is if you were to recommend restricting deceptive policies or practices and use the legislation to direct the training council to come up with a policy that can be enforceable through their standards and be trained, I think we'd be in a much better position.
Any questions from in here? Well, thank you for your testimony, Mr. Belangi. Is there anything else you wanted to close off with?
The only other stance we have is if this bill is going to move forward, we definitely agree with the Department of Public Safety's recommendations for the language change that I believe they submitted to Senator Sears this morning.
Yeah, it's on our committee webpage.
It's on your committee. Okay. And we would, the psychological part of it, I don't know that needs to be there at all.
Yeah, I do have one question, if I might,
Certainly.
since you have experience. When a juvenile is being the adult or a guardian ad litem or parent or whatever, do they stay with the juvenile during the interrogation, or are they just there to okay the interview or say no, he's not to say anything, or wait till he has a lawyer? And what is their role?
Anytime that I have seen, the parent should be requesting to stay there, or their disinterested party or their guardian or whatever should be, and you can't deny them to be in there, and they should be with the juvenile.
But are they regular in your experience?
In my experience, yes, they are. Either that or they request a lawyer.
Okay, thank you. That's all.
Is there any other questions?
Not seeing any more questions in the room.
Well, thank you for your time.
Thank you for your testimony.
Our next witness is from the ACLU, and in my usual capacity of messing up pronunciation of names, if you would help me, please. Indy.
Yeah. Hello, for the record, Indy Show.
Well, thank you for being with us.
Yeah, so happy to be here. This is my first time testifying in front of this committee. And so I just want to take a moment to introduce myself. This is my third time engaging with the Vermont legislature, each of which has been both challenging and a delight to be part of this process where we're making equitable policy. I grew up in Utah and I moved to Vermont in 2019, where I studied at Vermont Law School. And I was interested in constitutional and criminal law and the intersections that arise there. And currently I live in Burlington with my 2 cats. And I love this little state so much. So thank you again for having me and giving me the opportunity to testify on S6, an act relating to custodial interrogations of juveniles. So the ACLU of Vermont is committed to ending police violence and increasing transparency and accountability because Vermonters deserve to live equitable and secure lives. We know that accountability measures alone are not enough, and Vermont must also invest in our community programs that build sustainable community security and safety. So we support S6 as a measure to limit coercive police interrogations of juveniles and to prevent false confessions. So we urge that the same protections be applied to all police interrogations, which I will go into a little bit more. So just last week, the ACLU filed a lawsuit against a Vermont police department that extensively used false, misleading, and coercive interrogation tactics against multiple suspects and witnesses. Situations like these offend our values and sense of justice, and they can and should be prevented from occurring in Vermont. Just as it is wrong to allow police to lie to juveniles, to coerce false confessions, it is wrong to allow the same conduct for adults. So I want to just highlight 3 things here. First, coercive and deception interrogations often result in false confessions. Second, this legislation enables truthful and just resolutions and accountability. And third, it is wrong for police to coerce false confessions in any interrogation, regardless of a person's age. So coercive and deceptive interrogations often result in false confessions. We know that under Vermont law, police are permitted to use deceptive tactics on any person, regardless of age, during a custodial interrogation. And these interrogation tactics can and do result in people falsely confessing to an offense they did not commit. When looking at a study done by the Innocence Project, they found that of 211 exonerees who were wrongfully convicted as children, 36% falsely confessed, whereas 10% of exonerees who were wrongfully convicted over the age of 18 falsely confessed. This shows that youth are overrepresented in proven false confession cases, typically accounting for about 1/3 of the samples. In other words, juveniles are 3 times more likely to give false confessions than adults. And the use of deceptive tactics like the Reid method on children has led to an alarmingly high rate of false confessions among youth who are already at an increased risk for false confessions. These deceptive interrogation tactics ultimately harm the people our state has made the most vulnerable, that being people of color, youth, and people with mental or physical disabilities. These tactics also harm victims insofar as false confessions often result in an innocent person being convicted while the actual perpetrator faces no accountability. Data shows that BIPOC are overrepresented in the criminal legal system, including in exoneration databases and in instances of false confessions. Experts have found that people living with mental and physical disabilities are at a particularly high risk for exploitation and manipulation during interrogations, and youth are particularly susceptible to deceptive tactics because the part of the brain that controls like future planning, judgment, decision-making is not fully formed until about their mid-20s, so around my age. So recognizing the vulnerable position of justice-involved youth, S6 is a critically important and overdue step to mitigate the possibility of false confessions arising from our youth, and to also minimize the use of deceptive and coercive practices in policing as a whole. So even if these tactics are more likely to produce a false confession from youth, we believe it is just as important to end the use of deception tactics by police for everyone in custodial interrogations. There are many reasons to end deceptive tactics by police, and we want to center on the astounding lack of scientific evidence supporting its efficacy. Historically, the shift from a physical interrogation tactic used by police in the early 20th century to a more psychological interrogation method was thought to be a scientific and effective advancement that was more humane than intimidation and physical violence. But since its inception of this strategy, of this interrogation strategy, its efficacy has been conclusively discredited in scientific evaluations. And just to touch on the Reed method that was discussed earlier in testimony, this, I believe, was developed in the 50s. And scholars have since then called on a very legitimate question regarding its efficacy to obtain both truthful and reliable confessions. So science has developed since then. This method was introduced, and there have been many other alternatives introduced that result in more reliable confessions. And now that we know that confessions produced by police deception often result in wrongful convictions based on false confessions, it would make sense to implement appropriate guardrails so we limit deception and the possibility for false confessions. And finally, Essex enables truthful and just resolutions and accountability. As a state, we should strive to ensure that any confession is accurate, freely given, and obtained with interrogation techniques based in modern science. Illinois, Oregon, Utah, and California have prohibited the use of deceptive interrogation tactics as applied to juveniles, with support from both law enforcement and prosecutors. And the language found in Section 3 of S6 mirrors Connecticut's SB 306 provisions, which passed through Connecticut Senate, but not through both chambers. So this bill before us is specific to prohibiting threats, physical harm, deception, or psychologically manipulative tactics by an officer during a custodial interrogation of a juvenile. And this bill confronts the use of these deceptive interrogation tactics on juveniles by creating a presumption that statements from these interrogations in which an officer knowingly used specific coercive and deceptive tactics are involuntary unless the presumption is overcome by clear and convincing evidence. However, Essex does not go nearly as far as the legislation found in the Connecticut bill, which includes the most comprehensive abolishment of deceptive interrogation practices in the country. And we have an opportunity to join Connecticut in taking the lead to ban the use of deception or coercion in any custodial interrogation, regardless of an individual's age. So it's wrong for police to coerce false confessions in any interrogation, whether involving children or adults. So while we strongly support S6 as a good start, we also believe that deceptive tactics should be prohibited in any police interrogation, regardless of the age of the person in custody, to both increase transparency and accountability of law enforcement officers and also to minimize false confessions. The ACLU filed a lawsuit last week on behalf of John Chinichi, who was unlawfully arrested, interrogated, and searched by Bennington police after they repeatedly pressured multiple witnesses and suspects, in some instances, using the very same tactics this bill addresses, to name Mr. Chinichi as an accomplice in a January 2016 armed robbery. Police used these tactics to elicit a false accusation, despite the fact that Mr. Chinichi did not match witness descriptions and no other evidence connected him to this crime. And while trying to get Mr. Chinichi named as an accomplice, Bennington police arrested him without probable cause and went on to make multiple misrepresentations in their interviews with Mr. Chinichi and in their application for a warrant to search his phone. Mr. Chinichi was prosecuted based on evidence arising from these unlawful actions. Though his resulting conviction was eventually thrown out, Mr. Chinichi now asserts that Bennington Police Department officials in the town of Bennington violated his federal and state constitutional rights. And last session, we supported legislation that prohibited the use of deceptive and coercive methods towards all people. And we continue to urge.
Can I interrupt real quick? I'm sorry, Senator Bohos.
Yeah, thank you for your testimony. I've been kind of mulling around in my head the impact on people with disabilities and mental health challenges for a few days now. And I'm wondering if you have any statistics about the impacts of this kind of method on adults with disabilities, mental health issues, substance use disorder, and even low literacy.
I don't have that right now, but I would be happy to supplement some information and get that to you.
Thank you so much.
Yeah, of course.
And Senator Norris.
Hi, good morning. Thanks for being here. I'm not quite sure, Indy, if you're the person I should be asking, or quite possibly Nathaniel when he comes on in reference to the study of the Innocence Project. Are you just using those statistics from the study, or what I'm assuming of the 211 exonerees, we're talking about Vermont cases. He said we're talking about Vermont law here, obviously. And if I'm inaccurate in that, what area are we talking about this study was done in, and more importantly, how does this affect the Vermont statistics?
Yeah, I believe that Nathaniel's here from Innocence Project, but I believe that this study was done across the U.S. It's not just specific to Vermont, and we don't really have that information, given that there's not case law showing that. But that's not to say that false confessions are not occurring in this state.
But we're not aware of any presently, or you're not aware of any.
Yes, that's correct.
Thank you.
If you want to continue on, you were in the middle of talking about Mr. Chinichi and his lawsuit against the Bennington Police Department.
Yeah, thank you. So just given that this case with Mr. Chinichi has come up, we continue to urge the legislature to adopt an approach that expands to all custodial interrogations. Permitting deception or coercive techniques for adults is not aligned with the values of our legal system in our state. And this bill should be broadened once again to include all persons in a custodial interrogation. So just to reiterate, the ACLU strongly supports S6 as an essential step in creating a more accountable and fair legal system. And deceptive interrogation tactics, they're outdated, they're ineffective, and can and do result in false confessions, resulting in the incarceration of innocent people. And this is just inconsistent with the values of our legal system in our state. So again, we urge the legislature to act now and prohibit the use of these manipulative and deceptive tactics during any custodial interrogation. So thank you. Happy to take any questions.
I do have one question about your discussion of the Chinichi case. Obviously, I represent Bennington County and other Windham County towns. And I'm curious if what you state about the ACL lawsuit, if you state as fact that the Bennington police repeatedly pressured multiple witnesses and suspects, in some instances using deceptive tactics, etc. Are these things that have already been found, or are these things that the lawsuit is alleging?
I believe that these are things that have been found. I don't want to speak incorrectly, but given the use of deception and psychologically manipulative tactics that led to Mr. Chinichi giving a false confession, I believe that these are found. And then because it does go against, I believe, his Fifth Amendment right of.
No, I understand I'm just trying to understand if this is what the lawsuit's about, or if this is something that has already been found by a court?
So this is what the lawsuit is about, is that his
Right.
rights
Yeah,
were
maybe I
violated.
just,
Yeah.
I sensed this is a fairly sensitive issue. I do want to make sure that what we're hearing in testimony here are allegations and not fact at this point.
Mhm.
Whether it's all true or not, I'm not in a position to say, and I'm not defending anybody
Mhm.
here. Just want to make clear that what it is, because this is a public record and so forth.
Yeah, thank you for that clarification. We do appreciate the work that the committee is doing in this area, and we look forward to just continue working alongside of y'all in this process. So
Thank you very much.
Thank you.
Are there any other further questions?
Not in the room.
Okay, good. Are there any other witnesses on this today?
Oh, there we go.
No other witnesses on the agenda.
Aside from that.
Pardon me? We're scheduled to have Ben,
For markup.
yeah, for markup. Why don't we take a 5-minute break and get Ben organized and get ourselves organized?